Welcome to Spoken Injustice, where we put the criminal justice system in the dock. This video is entirely focused on the Criminal Cases Review Commission, the entity established to investigate suspected miscarriages of justice in England, Wales and Northern Ireland. We will explore its historical background, the reasons for its establishment and the growing calls for reforming or even abolishing it, as evidenced by a protest staged outside the CCRC headquarters on the 10th of May 2024. Stay with us until the end to gather all the information necessary for forming your own conclusions. If you are inspired, you may want to consider joining the campaign to advocate for these changes. So starting with the CCRC historical background. On the 14th of March 1991, the day in which the convictions of the Birmingham Six were quashed on appeal, the Home Secretary announced a royal commission into the criminal justice. The commission, known as the Runciman Commission, from the name of the chairman, was established for the purpose of examining the English system of criminal justice and making recommendations as to changes that should be made to increase the efficiency of the system and the effective justice inherent in the process. In its final report, published on the 6th of July 1993, the Commission recommended setting up an independent body tasked with investigating miscarriages of justice. Up until then, an unsuccessful appellant wishing to reopen their case could do so only by persuading the Home Secretary to refer their case back to the Court of Appeal. The Commission found that it was not desirable that the Home Secretary should be responsible for the consideration and investigation of miscarriages of justice, as well as being responsible for law and order and the police. The new body was envisaged as a body independent from the government and from the courts. While the Commission envisioned this new body to be independent from the government, it also recognized that the necessary resources for its operation will need to come from the government. As a result, they deemed it necessary to designate a minister responsible for appointing its members and answerable to Parliament for its activities. Curiously, these measures were not seen by the Commission as capable of compromising the new body's independence. Regarding interactions with applicants, the Commission anticipated that the new body should not expect individuals who have suffered a miscarriage of justice and are in prison to clearly and coherently present their cases. It expected the new body to be adequately resourced to conduct interviews with the applicants to determine whether their cases warrant investigation. The Commission also envisioned that the new body should have investigative powers to conduct its own investigation or to direct other entities to investigate on its behalf. The new body was finally set up in 1997 under the name of the Criminal Cases Review Commission by the Criminal Appeal Act 1995. We shall refer to it from now on as the CCRC. Part 2 of this Act implemented most of the recommendations made by the Runciman Commission. The Act also provides that the CCRC shall consist of not fewer than 11 members appointed by the monarch on the recommendation of the Prime Minister, and that at least 1/3 of its members shall be legally qualified. As per the CCRC powers to refer cases to the appellate courts, Section 13 of the Act provides that if the CCRC assesses that there is a real possibility that a conviction will be quashed in a court of appeal, it may refer the case to the relevant court where it must be heard. This is known as the real possibility test. The establishment of the CCRC was met at the time with a mix of optimism and skepticism. Many legal professionals and individuals who had been campaigning for justice welcomed the creation of the CCRC. It was seen as a much-needed mechanism to address potential miscarriages of justice, providing a formal avenue to review and potentially overturn wrongful convictions. Organizations focused on exonerating wrongfully convicted individuals supported the CCRC too. They saw it as an ally in their mission to correct judicial errors and bring justice to those wrongly imprisoned. The general public and the media viewed the CCRC as a step forward in ensuring fairness and transparency in the justice system. It was believed that the CCRC would help restore public confidence, especially in light of the several high-profile wrongful convictions in the preceding years, with the Birmingham 6 case being one prominent example, and indeed the catalyst for the establishment of the CCRC. However, some critics were skeptical about the CCRC independence and ability to act without bias. They questioned whether it would have had sufficient authority and autonomy to challenge decisions made by the courts. And there were also concerns about whether the CCRC will be adequately funded and resourced to handle the volume of cases and conduct thorough investigation. Critics worried that without proper support, the CCRC might not be effective in addressing the backlog of cases. But by far, the greatest concern already then was that the high threshold set by the real possibility test for referring cases to the Court of Appeal may result in deserving cases not being reconsidered. Over the years, the skeptical voices were proven right. Following increasing criticism directed at the CCRC, the House of Commons commissioned an inquiry into the CCRC in 2013. Witnesses to this inquiry included Viscount Runciman and Professor Zander, who presided over the original Royal Commission in 1991. Before embarking on the findings of this inquiry, if you're finding this video useful, hit the like button below and subscribe to our channel to help us in our mission to humanize wrongful convictions. So back to the 2013 inquiry into the CCRC. The Select Committee acknowledged concerns about inconsistencies in approach and expertise amongst case review managers within the CCRC. They concluded that there was still room for improvement, particularly regarding the CCRC's level of engagement with applicants, and recommended increasing the frequency of meeting with applicants to address this issue. They also recommended that the CCRC took advantage of its unique position and develop a formal system of feeding back into the criminal justice system on the causes of miscarriages of justice. However, the Select Committee found that the real possibility test was one of the most controversial aspects of the CCRC. They said, "We found the criticism broadly fell into one of three areas. That the test itself is wrong, that the test is being applied incorrectly by the CCRC, or that the Court of Appeal's approach to criminal appeals is overly restrictive." They eventually settled for the latter, comforted by views from some of the witnesses to the inquiry, such as Professor Zander and Paul May, for example, who has been involved in numerous miscarriages of justice campaigns notably the Birmingham 6 and some Harlem. He asserted that much of the criticism levelled at the CCRC would be better directed at the Court of Appeal, which remains capable on occasions of quite breathtaking obduracy towards appellants claiming wrongful convictions. So rather than opting for the changing of the real possibility test, the Select Committee recommended that the Law Commission review the Court of Appeal's grounds for allowing appeals. They say this review should include consideration of the benefits and dangers of a statutory change to allow and encourage the Court of Appeal to quash a conviction where it has a serious doubt about the verdict, even without fresh evidence or fresh legal argument. If any such change is made, they said, it should be accompanied by a review to its effects on the CCRC and the continuing appropriateness of the real possibility test. However, their overall conclusion was that the CCRC, though it could be doing more to increase understanding of its work and was in need of further resources, was performing reasonably well and remained as important and as necessary a body as ever. The inquiry eventually led only to a small addendum to the Criminal Appeal Act 1995, that was the insertion of Section 18A, which extended the CCRC powers to obtain documents and other material, not only from a public body, but also from private individuals. A further tailored review was commissioned at the wake of the CCRC 20th anniversary in 2017. This was open to people and organizations with an involvement or interest in the CCRC. 46 responses were received in total. The review concluded that there was still a clear need for the functions of the CCRC, however, made a number of recommendations. It overall found that the CCRC continues to be an effective and efficient organization and that the recommendations contained in this report will enhance its work. Let's remember that this review was conducted during the years when Mr. Malkinson's persistent claims of innocence and requests for further forensic testing were rejected by the CCRC. As you likely know, and as it was made clear by the documentary The Wrong Men 17 Years Behind Bars, aired by the BBC Two on the 7th of June 2024, the CCRC refused to commission forensic work in Andrew Malkinson's case. This was despite the presence of an unidentified male DNA on the victim's clothing. It wasn't until years later that DNA evidence, eventually commissioned by Malkinson's legal team, proved his innocence. Evidently, this review did not accurately reflect the reality, as also now confirmed by the damning report from Chris Henley KC, which we are still awaiting publication. It is in this context that the Empowering the Innocent project, established in 2019 by Dr. Michael Norton of the University of Bristol Law School, launched the CCRC Watch in February 2022. The CCRC Watch was established with the aim of highlighting the limitation of the CCRC in handling applications from individuals who claim to be innocent victims of wrongful convictions due to the restrictive nature of the real possibility test and the requirement for fresh evidence. Dr. Norton is a leading academic expert on miscarriages of justice. For over 20 years, he has considered the inherent failures of the criminal justice system insofar as wrongful convictions are concerned in a number of academic books, peer-reviewed academic articles and other publications. Dr. Norton described the current state of the CCRC as a lapdog. CCRC Watch calls for the abolition of Section 13, the real possibility test, so that the CCRC can be transformed from a lapdog into a true watchdog, focused solely on identifying and referring actual miscarriages of justice rather than worrying about how the Court of Appeal might rule once the case is referred. These concerns intensified and were further highlighted by an all-party parliamentary group on miscarriages of justice and eventually led to the commission of a major review on criminal appeals announced by the Law Commission in 2022. We have covered this in our video, The Law Commission and the Criminal Appeals Reform, which you can find linked in the description below. In short, the Law Commission reported that several bodies have argued that there is a need for reform and set out to establish, amongst other issues, whether the test of real possibility encourages the CCRC to be too deferential to the Court of Appeal and to seek to second-guess what the court might decide, rather than reaching an independent judgment of whether there may have been a miscarriage of justice. They are also seeking possible alternative tests that will better enable the correction of miscarriages of justice. However, since the announcement, there have not been further developments. The deafening silence from the Law Commission, combined with the sobering report by Chris Henley KC, has intensified the pressure. Many are questioning whether the CCRC is becoming more of an hindrance to addressing wrongful convictions rather than the solution, and are calling for immediate reform. Enough is enough, they say. On the 10th of May 2024, a group of campaigners by the name of Innocent Failed by the CCRC, set up by the Jeremy Bamber Innocence Campaign, JBIC, demonstrated outside the CCRC headquarters in Birmingham. Peter Tatchell, human rights activist, delivered a letter to Helen Pitcher, chair of the CCRC, calling on her to publicly respond to the issues raised at the demonstration. The main criticisms highlighted were the CCRC inefficiency and delay. They argue that the CCRC is too slow in handling cases, leading to long waiting times for those seeking justice. CCRC bias. They are concerned that the CCRC is too aligned with the police, potentially leading to bias against those claiming wrongful convictions. Indeed, they say some CCRC employees are former police officers. They argue that this alignment impacts its impartiality. CCRC refusal to pay or commission forensic work, as demonstrated in the case of Mr. Malkinson. They also have concerns about the CCRC high threshold for referral. The high bar set for cases to be referred back to the Court of Appeal results in clearly deserving cases not being reconsidered. Peter Tatchell concluded his speech delivered outside the CCRC Birmingham headquarters with,
"It's time for reform. It's time, if necessary, for abolition. We cannot continue with the CCRC in its present form. It is not fit for purpose."
The demonstration was independently filmed and a video can be accessed through the JBIC's YouTube channel. The link is provided in the description below. The event was also well covered by Peter Tatchell at petertatchell.net. Again, the link to this page is provided in the description below. And what are your thoughts? Do you believe that abolishing the CCRC is the solution? Or could reforming the CCRC through measures such as improving transparency, allocating more resources, and refining referral criteria preserve what many see as a crucial component of the justice system? And indeed, if you advocate for abolishing the CCRC, do you think a new entity should be created in its stead? And if so, what should its structure, authorities, and referral criteria look like? Share your thoughts in the comment below. We look forward to hearing from you. This concludes our session today. I hope you have a clearer and unbiased understanding of the current state of the CCRC, which is essentially a body on its last gasp. Can it survive? We hope we have inspired you and given you more reasons to join us in our effort to humanize wrongful convictions. If so, please like this video, subscribe to our channel, and join our networking hub at spokeninjustice.net to become a leading voice in the fight against injustices in our criminal justice system. We look forward to usher you next time as we sit and rise in this unique trial.